We are now live and on the record. Hear ye, hear ye, hear ye, all persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Okay, thank you very much. Good morning and Happy New Year. I assume, Attorney, by now that you are familiar with the Zoom platform that we use for remote arguments. But I'm just going to give you a few preliminaries to start with. One is, if we have any technical difficulties, just be patient. We usually work them out quite quickly and you won't lose any of your time. The regular rules that apply to oral argument in the courtroom apply to remote sittings. So you have 15 minutes to present your argument. I don't have to tell you that there's no rebuttal because the other side is not appearing today. So it'll just be you and presenting your argument in the 15 minutes allotted to you. That square that you see on the screen where our clerk just was a moment ago will turn to a clock and we'll tell you how much time you have remaining. So with those preliminaries aside, I'm going to introduce the panel to you. My name is Ariane Buno. I'm joined today by Justice William Mead and Justice Marguerite Grant. This case is number 2021-0274. APT, which I assume is short for apartment, APT, Apartment Management Inc. versus Stephanie Newcomb. Attorney Megaludis, did I pronounce that correctly?
Megaludis, it's close.
Megaludis. Attorney Megaludis, please begin your argument.
Thank you. Good morning, Your Honors. May it please the court, my name is Natalie Megaludis on behalf of the Plaintiff Appellant APT Management. The issues on appeal involve the requirements under General Laws, Chapter 139, Section 19, known as the Expedited Eviction Statute, as they relate to federally assisted housing, and the differences of this statute, and the remedies that are brought under the Summary Process Statute, Chapter 239. The first argument I want to present before the court involves the Housing Court's determination in its finding and order of judgment that the notices under both statutes constituted notices to quit. As this court is aware, having read the materials and briefed the arguments, there were two actions that were filed in this case that were brought under separate times. The first one was in March of 2020, and the second one was 6 months later in September of 2020. The issue here that the lower court did not apply correctly was that the first action was filed under the Summary Process Statute, Chapter 239, on the basis of material violations of the defendant's tenancy.
Right, which would include non-payment of rent and the failure to meet with at the two inspections that were conducted, right?
Correct, for the conditions in the unit, specifically the damages that were sustained to the unit. Those were the violations of the unit that were brought under the Summary Process Statute, Chapter 239. The second action was filed as a specific civil injunctive relief. That's under a separate statute under General Laws, Chapter 139. That's known to as and referred to as the Expedited Eviction Statute. And these are
Can I just jump ahead for a second and ask you a question? Okay. And this I don't know if this is in your favor or not, but when the trial occurred on December 15th, 2020, the judge specifically asked if both cases could be heard simultaneously, if the summary process action could be heard at the same time as the civil case to void the tenancy under Section 19. And everybody agreed that would be the case, correct?
That's correct, yes.
Okay, so not to hand you an argument, but what exactly does that mean? In other words, if the issue is that the judge says there's two notices to quit, which I know you disagree with, and the reason why the judge feels as if that's problematic is because there's two different signals sent to the tenant. On December 15th, 2020, at the trial, the tenant was aware of the fact that both cases were proceeding at the same time.
That is correct, Your Honor. So I think that there's two responses to your argument. The first one, which is what Your Honor just stated, which is that both parties knew about the two factors and both parties agreed to have them both heard. So it was all by agreement that these two notices would be presented.
Well, let me ask you this, because this is what I want to get to. Actually, what the judge said was, can they be heard simultaneously? He didn't, and not really joining them. Does that make any difference in your view?
No, Your Honor, because the two cases and the two forms of relief can be brought simultaneously,
Okay.
and for two reasons. Number one, they're not two notices, and that's the first argument that we're signaling is that the one is a notice of termination of tenancy brought under 239. The second one is not a notice to quit. It's a separate notice that has to be filed for federally subsidized properties under Chapter 121B, and it's a notice to vacate. It's a voiding of tenancy. It doesn't terminate the tenancy. There wasn't any understanding that there was a tenancy in existence, that it was being reinstated in any way. It's a wholly separate statute that's given under a separate form of relief. And,
yeah, but still in all, if you look at the two notices, the one dated January 22nd, 2020, which was under the summary process statute, that tells the tenant to leave by February 29th, 2020. The next one, dated September 17th, tells the tenant to leave by September 23rd, 2020. So whether or not they're two separate statutes and two separate actions, why is not giving the tenant a misleading information?
Because in either circumstance, and in the case law, both McGuire and the other case law that follow, McCarthy, what it deals with is the inconsistency of the messaging. And in this situation, the tenant didn't vacate in either. So there can't be an argument in a certain way that the tenant was prejudiced by it in any way. The tenant remained, the tenant stayed in the unit, and both cases were tried and heard.
That was another question I had, because during the course of the trial on December 15th, the tenant says that she's been locked out of the apartment, that she has not had a chance to go back. So it appears that she was not living there at the time. Can you explain that?
I seem to remember that the comment had been made, although that had been for various times that had been regarding a hospitalization. It wasn't related to anything regarding her tenancy or any action that the management had taken, that she had been locked out. She had issues regarding access to the unit. This was not part of the case in chief. It was just more of a comment that was made.
Okay.
But to get back to it, the legal requirement pertains to the sufficiency of the notices and the fact that whether or not there's inconsistent messaging. These two separate statutes and the reliefs that are afforded under them by the legislature specifically require that landlords be permitted to file both and can proceed under both. The whole purpose, which is the second requires the second argument that we make, is that the legislature specifically created Chapter 139, Section 19 for circumstances such as these. And it would be inconsistent to state that a landlord who files a summary process action for violations of a lease, and then while waiting trial, such as this, commits a violation that constitutes an egregious situation, such as a crime of violence or prostitution, things of that nature, would then not be able to bring a separate action under a whole separate relief that's afforded, which is the civil injunctive relief. Nothing in the statute suggests that the relief is that both actions can't be filed for wholly separate reasons. Again, these aren't inconsistent messaging. It's not to state, like in McGuire, where a notice of reinstatement of tenancy had been given and then subsequently a second action had been stated to terminate a tenancy. That was the situation in McGuire. In this case, these are wholly two separate acts that occurred and a separate action, a separate violation that occurred under Chapter 139.19. And these are two separate bases for voiding.
Can I ask you a question? Doesn't Chapter 139, Section 19 say right in the body of the statute that a landlord or owner can either proceed under this statute or under the summary process statute? I'm pulling up the statute now. It says that in the body of the section, right?
Correct. And that's as it pertains, and that's an important distinction, Your Honor. That's as it pertains to the actions of the violation. So the landlord in this instance could have brought, for the fire incident that gave rise to the 139.19, the landlord could have brought either a 139.19 or a summary process statute. But there's nothing in the statute that states that if you have a separate violation for something that occurred before this, that somehow a landlord is now waived and precluded from filing a 139.19 because there is something that's unrelated that occurred 6 months prior. You can get two forms of relief for the same offenses, but you can't, in this situation, what we have are two separate violations on two separate dates that involve two separate independent forms of relief. And in this case, the landlord did elect to file a 139.19 because there's an obligation to do so. And under 139.19, the legislature recognized that there are specific instances where a landlord is not only needs relief to go on an expedited basis and file civil relief that's even more, that gives more remedies. But under section 139, section 20, a landlord is actually obligated to do so and can face criminal penalties for not taking prompt action in pursuing these. So we have here a situation where there's two separate forms of relief that were given, and nothing that occurred 6 months prior waived that. And where the lower court found that the plaintiff had prevailed on the first action and actually met its burden and established that there were non-payment and established that there had in fact been violations of the lease, the lower court erred in essentially stating, but all of that is voided because you then proceeded under a 139.19.
That particular complaint, the summary process complaint, was dismissed at that point without prejudice, right?
The cases that were both tried, the first one, the judges and his findings and rulings stated that no, on that action, that while the landlord had prevailed, that in that action the landlord couldn't get judgment because the 139.19 waived the 239.
No, I understand that, but what prevented you from going forward the following day and filing another complaint under the summary process statute?
Could have retried the issues that had occurred 2 years prior under the summary process. Nothing had precluded that. I think that since then we filed the appeal and then we proceeded on that basis, and then or could have prevented the landlord could have in fact filed another eviction for those issues. I think the issue here, Your Honor, is that as it's presented is that having prevailed on its first case, there was nothing in the statute that stated that in the 139 that stated that they couldn't go forward because two notices to quit had never been filed, and that was an error. And the plaintiff is entitled to relief under having prevailed in the first one. I do want to. Does that answer Your Honor's question before I move on?
Well, I have to say I never practiced in the housing court, so I'm not going to pretend I have any information or background in terms of how to handle things expeditiously. But I was curious with the fact that it seemed to me it might have been quicker to have proceeded again with another summary process complaint than take the appeal. But that's just you can just feel free to disavow me of that opinion.
I can state that the summary process statute isn't as a summary as always, especially where you have issues of trial and jury trials and rights. Ever more so with the pandemic, which has never made things longer.
So in terms of practicality, it might not have been the most expeditious route.
And wouldn't this is an issue that could recur that you'd want resolved, right?
It is, Your Honor, because I think, as your Justice Mead is indicating, the issue really involves, especially where the judge ruled where two notices to quit had been served, one invalidates the other. The fact that there is a situation where if you have a violation of a tenancy and you proceed on one case, and in the interim, you have an egregious situation, such as a 139.19 violation that comes up in the interim, and a landlord states, I have this relief, I'm required to take action. I'm required under Section 20 to take prompt action to protect the other residents in a building. It is an illegal issue that does have to be addressed because it does is something that can come up again and needs to be addressed, because if something should come up like this, even within this action, even within this defendant or any other defendant, the issue does need to be addressed. It isn't a situation of blowing hot or blowing cold or choosing one position and sticking to it like the case law has stated, is that these are two separate independent bases, and there isn't any confusion within whether or not a landlord in this case or any other case is terminating a tenant. It really depends on what relief you're seeking and the rights to proceed under both. I want to move quickly with the time that I have left to discuss where the plaintiff and the lower court found that the elements of the Chapter 239 summary process case, the violations case, and the plaintiff had prevailed on that. The lower court then stated that the plaintiff did not sustain its burden on the Chapter 139. And that relates to the sufficiency of the evidence, and understanding that the standards are very different in that argument. I did want to touch upon the fact that the lower court had indicated that the plaintiff did not sustain its burden because no evidence of criminal charges had been introduced, or a police officer did not testify.
What if the judge, sorry, what if the judge had said, I believe the tenant's testimony, that she did not say those words to the other woman walking by? Would that have been, would your argument be different?
It would be, because that would have been the finding of fact, and you take your facts as the fact finder finds them. But in this situation, it was the basis for the ruling and the findings that were made, that somehow the plaintiff had the burden to introduce the evidence of criminal charges. And while the statute, Chapter 139, does refer to criminal charges, that's not the element of the case that needs to be established. It's referred to as chapter, the Controlled Substances Act, and it's referred to violations of criminal acts. But the criminal acts, charges of the criminal acts themselves don't have to be. And as I've argued in my brief.
Well, what is the standard of review then? What is? What quantum of evidence do you have to show that the violations occurred?
Well, I would submit that making those findings that those were elements that needed to be established was an error of law, because that's not the actual standard that needs to be introduced in order for a plaintiff to prevail. It really is based on the evidence that was introduced. And in this case, we did have a precipient witness who testified that she saw the burnt towels and the burnt paper towels under the door.
Okay.
So
I see. That's okay. I see your time is up. So none of your arguments are waived. We'll consider all of them when we look at your brief. I'm just going to check with the panel to see if they had any additional form for oral arguments. But just in case you're not, upon occasion, rarely, we have some technical difficulties. If we do, just be patient. They will be resolved, usually resolved quite quickly, and nobody will lose any of their time. The rules pertaining to oral argument apply equally to remote arguments. You each have 15 minutes to make your argument, and there is no rebuttal in the appeals court. Now I'm going to introduce the panel to you. My name is Ariane Buno, and joining me today is Justice William Mead and Justice Marguerite Grant. This case is number 2021-0266, Jackson Woods Investments, LLC versus the Town of Holding Planning Board and others. And I believe Attorney Kritsky, you go first. You may begin your argument.
Thank you, Your Honor. Good morning, Your Honors. George Karitzi. I represent Jackson Woods Investments, LLC, the appellant. May it please the court. I would suggest that this is a case of first impression. It involves a planning board denial of a petition under General Laws 41, Section 81W to amend a subdivision approval. The Holden Planning Board duly conducted a public hearing, voted its decision, filed its decision with the town clerk, and Jackson Woods timely appealed that decision under 81W to the land court. The town moved to dismiss the appeal, arguing that the appeal was really an appeal of the 2018 original decision under 81U, and thus time-barred. The land court agreed, and Jackson Woods has appealed the dismissal. Despite nearly 70 years of subdivision control, this case presents the first case where there's a dismissal of a denial of a modification under 81W. Before I dive into the specifics of this case, I'd like to just briefly discuss subdivision procedure. Applications for a subdivision are made under 81U. The planning board holds public hearings, sends out notice, conducts the hearings, closes the hearings, votes, and files a decision with the town clerk. There's a 20-day appeal period. After the 20-day appeal period, if there's no appeal, that decision is fixed until the approval is later amended, modified, or rescinded. Any interested party may apply to the planning board to amend, modify, or rescind the subdivision approval, and that is made under 81W.
I have a question for you, Mr. Karitzi. back in 2018, when the board originally approved the subdivision plan that included condition 5, was Jackson Woods aggrieved yet by condition 5?
No, Your Honor. It was not atypical for Jackson Woods to go through this. They have several subdivisions. The principals of Jackson Woods have had several subdivisions in Holden, worked very well with the planning board. Things had gone well. Back in 2018, when the decision was made, the DPW said they don't have the staff, the engineering department doesn't have the staff to do the inspections. So could we hire outside inspectors to do it? Jackson Woods said, no problem. It doesn't matter to me who I pay, whether I pay the town or I pay your outside person, not a problem. DPW director then decides to hire an outside engineering firm, and they go to the site 10 hours a day.
Well, I thought that under the subdivision plan, Jackson Woods was entitled to name 3 possible inspectors, and the town would pick from among the 3 inspectors that Jackson Woods nominated. Is that not how it's working? What's with this?
They did, Your Honor. That's exactly what happened. What happened here, however, is that when the town chose one of the inspectors, we chose the inspector, they sent them out to the site. DPW wanted the inspections 10 hours a day. And they said they had to be on site while all the pipes being laid. Rather than going out and inspect the work when it was done, they had a young engineer right out of school sitting over the trenches. And literally before phase 1 was half done, the entire budget for inspections was already exhausted. Over $100,000 was spent on inspections. That was never done at any time with any of my client subdivisions in Holden.
Wouldn't that have been obvious though from the condition, the sentence in condition 5 that says the inspector will be on site for all site preparation and infrastructure?
That is, but they don't, I'd suggest that that's never been done. What happened every single time is that they come out, they do an inspection. It usually takes an hour a day to walk the site to see the work that was done that day. And that's what Holden had always done. So that's what we were expecting. When they said, we're going to have him out there every single minute of the day, the cost was so exorbitant that my client said, I'm not doing it anymore. I said, no, you can't just do that. There's a procedure you need to apply to the board to give them the opportunity to revisit this. That's the reason.
Let me ask you a question. So then in response to Justice Grant's question as to whether or not your client was aggrieved at the time that condition 5 was initially agreed upon, the answer is no. You were aggrieved later in your view because it became so expensive. Is that right? Would you say then that was and I know your position is you don't have to show any material change. I understand that, but why is that not a material change? Or why did you not allege that would be a material change? Or what do you have to say about that?
So in the complaint, the reason I didn't put that in the complaint was I wasn't going to get into the merits or the genesis of the application. We had gone through the whole hearing at the board. The board had done that. I'm entitled to a de novo review at the land court to go over those issues. That would have been done at trial. And whether or not that condition was reasonable was something that the court would decide at trial. What we have here is that we're not even getting to that point. I made the application, we made the application under 81W. The board took it up, reconsidered the condition, voted it down, and we appealed. Never expected that it would be dismissed because we did an appeal in 2018 because that's so inconsistent with subdivision control, where you always go back to the board. They invite liberal revisits. And it just made no sense to say that if we make the change, that's appealable. But if we don't make the change, it's forever fixed. You're stuck to it because you didn't bother to appeal us back then.
Well, you wouldn't be stuck to it if there was a material change. And the judge made that clear, if I understood what was the decision.
I would suggest that that's not in the statute. So in zoning, like for instance, under section 16 of the Zoning Act, you can't go back when an adverse decision, you can't revisit that for 2 years. There is a blockout or a lockout period unless there's a material change in circumstances right in the Zoning Act. the subdivision control law at section 81W doesn't have that provision, doesn't require material change in circumstances. Any party can go to the board and ask them to revisit in approval. And by the way, it's not simply just the plan, it's the approval. And what's being appealed here was what we amended or sought to amend with our 81W petition was the approval, the condition of approval. And we're saying to the board, this is exactly authorized under 81W. And that's the procedure that Jackson Woods did here.
Well, what about the question that if that's the case, your client or a person in your client's position can obtain approval for a subdivision, agree at that time not to object to, let's say, conditions 1, 2, and 3, which made to the owner, to the person building the subdivision. That's onerous. That's going to cost me way too much money. I'll deal with that later. Then deals with it later, way beyond the 20-day period where you should have, where appeals should have been made if you didn't agree with those conditions in the first place. What do you say to that argument, which is an argument that's made in the town's brief?
Well, the issue is that I would suggest that under 81W, under the subdivision control law, for any reason, if things are not working out, that you can go to the board to ask them to revisit their conditions. This is not like a zoning matter where the zoning board of appeals grants a special permit and then walks away, leaves it up.
Is there any case law that supports that? Because I was looking at a case that's cited by, and it was actually addressed at the hearing, Sergi versus Planning Board of Kingston, which is a rescriptive opinion. And it basically says that in this case is a slightly different factual situation, that the plaintiff's appeal from a modification of a subdivision plan does not revive the original issues that were determined by the board when the subdivision plan was approved. Seems to me that's exactly what you are trying to do here. You had condition 5 that was agreed upon, did not appeal condition 5, and then a couple of years later say condition 5, complying with that is way too expensive. That could be a material change, but we're putting that aside right now. It's way too expensive. I want to revisit that. I want to revive the validity of that condition, which of course, in this case, we said cannot do because the 20-day period of time to appeal has gone.
Your Honor, I love the Sergi case, so I'm glad Your Honor brought that up. I was going to point it out. I actually believe the Sergi case supports the appeal. Because
I was wondering what you heard about, because you didn't really accept it.
I'll tell you why, Your Honor. Because in the Sergi case, what the court says was that the statute does not permit an appeal. This is a quote from the statute, does not permit an appeal of a modification plan to revive matters unchanged by the board and not reconsidered. This was reconsidered. The fact is that this board took up section 5, condition 5 again, reconsidered. So I'd suggest that the reason Sergi lost her appeal was because she's raising issues that were not part of the amendments. Had it been part of the amendment, had it been reconsidered, I believe that there would have been a valid appeal under 81BB, because any interested parties can, in fact, is in that case.
So are you saying then that had the board said to you, you're asking us to reconsider condition 5, we decline. We're not going to reconsider that because there was no objection to it 2 years ago, that then you would not have had the appeal, but only because they did take it up and have the hearings and have the public hearings, then that's the reason why you're in a different situation than the plaintiff was in Sergi?
I don't think a planning board can refuse to take up a petition.
Okay.
Anybody can apply to amend the subdivision. The planning board then takes up the application. And the whole point of this is to make sure that the matters that, for instance, there were several conditions that we did not appeal or apply to the board to amend.
Well, and if under 81BB, if the board had just failed to act on your petition to amend, you could appeal their failure to act, couldn't you?
I could, Your Honor. That would, in fact, I would be able to come here and say either the failure to act, or it may even been considered constructively granted. They went through the whole process, which is part of the frustration, recognizing from the beginning that there is a process. We have a public hearing. It went over several months. And during the several months, they voted on it. And this is no disparagement of the board. They gave us a full hearing. It was well received. They disagreed with us. And that's why we're going with this. And there is this appeal process. So the board gave us the hearing. They said, we've got your petition. We're going to undertake it. We send out notices to all the abutters. We have hearing after hearing after hearing. They make a decision. They grant us some of the changes. And then they didn't give us this one. And we, at the hearing, we had originally applied to change like 15 conditions. We withdrew most of those conditions at the hearing and said, these are the ones we need. And those are the ones the board voted on. And they recognized we withdrew the request for the others. Now, I would suggest that if we, let's say, for instance, this appeal, if we were asking this court or asking the land court to review those conditions that the board did not consider, because we had withdrawn it, the board didn't consider it, but now we want to ask the land court to declare those conditions void. I would suggest that is wrong. That's a collateral attack of a 2018 decision. But when you're asking them to review conditions that were the subject of the 81W petition and the subject of the 81W decision, the land court is a court of competent jurisdiction, and this appeal was properly filed within the 20 days. I have several questions. I know I'm running out of time. I'd rest on my brief on the rest of the issues unless the court has any questions.
I'll check. I see Justice Grant saying no further questions. No, none of your arguments will be waived. Don't worry. And thank you very much for your argument. We'll turn now to Attorney McKay.
Okay. Good morning, Your Honors. David McKay from Myrick O'Connell on behalf of the Holden Planning Board. This case raises the issue of whether a party can avoid the 20-day limitations period in the subdivision control law by applying for an amendment and then appealing the denial of that amendment. And the Planning Board submits that the answer to that question is no.
The legislature seems to disagree with you, though.
Certainly the applicant disagrees, no question with that.
No, the legislature.
I don't think so, Your Honor. Respectfully, the statute certainly provides an opportunity for an applicant to amend a special permit approval, to seek a modification, and so forth. But a party only gets one bite at the appeal apple. And under Section 81W, which provides for the planning board's ability and an applicant's ability to seek a modification or an amendment or a rescission of approval, as well as to seek a change in the subdivision plan, a planning board can entertain that under Section 81W. So there's no, I don't think there's any.
I have a question for you about the language of 81BB. 81BB says that any person aggrieved by any decision of a planning board concerning a plan of a subdivision of land was the board's denial of the motion to amend a decision of a planning board concerning a plan of a subdivision of land.
I think the answer to that question is that, yes, it was a decision with respect to a subdivision plan because it sought an amendment of the decision that approved that plan. So I think it would be a stretch to say that it doesn't relate to a subdivision plan. However, the statute also sets a strict 20-day appeal deadline, and Section 81W also intersects with that, and I think has to be read along with Section 81BB, such that what is appealable is a modification, amendment, or rescission of an approval, or a change of the plan. And where
but if the legislature wanted that to be the law, why wouldn't they have written BB to say any person aggrieved by an initial approval of a subdivision or a major change or a refusal to make whatever it is that you're saying. It says decision of a planning board concerning a plan of a subdivision of land. That seems to me to incorporate a denial of a motion to amend.
No, because I think it has to be read in concert with section 81BB, the second sentence of which says that all of the provisions, which I would assert include section 81BB of the subdivision control law relating to the submission or approval of a plan of a subdivision, shall, so far as apt, be applicable to the approval of the modification, amendment, or rescission of such approval and a plan which has been changed under this section. So where the appeal rights kick in on an amendment is where the amendment makes a modification, amendment, or rescission of the approval, or where the amendment changes the plan in some fashion. I think those two statutes interconnect there because the underlying principle behind subdivision control, similarly under Chapter 40A, is to provide for predictability and finality in subdivision decisions and in similar zoning decisions. This is captured in the Iadice case. And the idea is that once a decision goes final, once the 20-day appeal period has passed, parties should be able to rely upon the fact that that decision is now final. Doesn't change the ability of a planning board to modify or amend a decision. And if it makes a modification, if it makes an amendment, if it rescinds a plan, if it makes some change to the subdivision plan, then that becomes reviewable on appeal. But if there is no change made, if there is no change in circumstances that would justify a new appeal, the appeal rights have passed. The question in the context of the
land court, why didn't the land court judge need to hear more evidence and have a discovery process to determine what the Jackson Woods means by the exorbitant costs? What if it was a situation, and I'm not saying this is what's happened here, what if it was a situation where the developer signs on to condition 5, they think they can live with it, and then construction starts and the DPW says, the only inspector we're going to improve on your list is my brother-in-law, and he needs to be there 24/7. Wouldn't that be a situation where the land court judge, after discovery, should decide that the costs are exorbitant and it's a material change?
Not in the section of an 81BB appeal, Your Honor, because there is an appeal and there is an oversight process for exactly the kind of situation that you're talking about, Your Honor. If a planning board or if a town appoints an inspector that shouldn't be there, there's a statutory process and a process under the subdivision regulations that allows a party to take an appeal of that and to seek redress for that. So that specific situation is addressed. Similarly, if the plaintiff, if the developer has a problem with the application of condition 5, in other words, it takes the position that the Department of Public Works is violating condition 5 in some respect by charging exorbitant fees or appointing a brother-in-law to be the inspector, those kinds of things, the applicant can go to the planning board, which retains oversight of the entire subdivision, and say, the DPW is doing this improperly. That's not what section 5 requires.
Well, and so what if the planning board then says, too bad, denied? Can the developer appeal to the land court?
Yes, the developer can, probably to the Superior Court, possibly the land court, but that's not a section 81BB appeal. That's not an appeal of the a subdivision approval or an appeal of the subdivision condition. The subdivision condition is there. It has never changed. What the plaintiff is appealing
at that point. What section does authorize an appeal from that?
Excuse me?
From the scenario that you just described, what section does authorize an appeal? In other words, if you go to the board and you say application of condition 5 is being violated, by the DPW. They have the right to do that. The board says, we disagree. What section, under what section do they apply, and why would it be to the Superior Court versus the Land Court?
It would be a mandamus, excuse me,
I mean,
it would be
okay,
a
mandamus.
certiorari appeal,
All right.
and that could be taken to the Superior Court.
Right.
I'm actually not 100% sure if the land court jurisdiction would extend that far. It probably would, but I'm not sure of that particular piece. But actually, in this case, the plaintiff has done precisely that. The plaintiff has had a problem with the application of Section 5 and has taken 3 related appeals with respect to the oversight of subdivision constructions. They've brought 3 separate cases in the Worcester Superior Court on precisely those kinds of issues, demonstrating that there is a mechanism for a subdivision developer to seek seek redress for a planning board's allegedly improper application of a condition of a subdivision. What the plaintiff was aggrieved by in this case was the original condition 5, which has never changed. And so if the plaintiff has a problem or believes that condition 5 has been applied to it in an improper fashion, or the planning board has violated it, or the Department of Public Works in its oversight has violated Section 5, then there is redress for that. But and that can be done by way of a certiorari action under Chapter 249, which the plaintiff has done in 3 other cases in the Worcester Superior Court. But it doesn't change the underlying appeal rights under the subdivision control law, because here nothing about Section 5 has changed. Under Section 81W, what can be appealed, and I think the cases support this, the Sergey case supports this. The courts look to what was the real nature of the appeal, what was the plaintiff aggrieved by? Was the plaintiff aggrieved by the original condition, or by some element of the plan or the original decision that was changed by the planning board? And here, since there's been no change, what the plaintiff was aggrieved by was the original condition 5.
So you're saying, Mr. McKay, that only changes in conditions get judicial review under 81BB and not denial of request for changes?
Correct. Otherwise, the statutory limitation of 20 days under Section 81BB for any original subdivision plan becomes effectively meaningless, because that can be revisited at any time simply by an abutter or an applicant, or even some other town board. Any person aggrieved could seek an amendment and then appeal the denial of that amendment. So
I have a question for you. One of the other things that Jackson Woods sought to amend was condition 84, which Jackson Woods said was illegal because, as I understand it, they had a problem with the fact that it could be construed to require them to spend bond money on plowing and maintenance. And the board said, okay, that's not what we meant, but we'll rewrite the condition to make it clear that Jackson Woods has to pay for plowing and maintenance, but you don't have to spend bond money on that. If the board had said, too bad, we don't care if it's illegal, you've got to spend bond money on plowing and maintenance, are you saying that Jackson Woods wouldn't be allowed to appeal?
That's right.
Denial? Huh?
They wouldn't be appeal. And the Sergey case even addresses that it says this is so even if the original decision of the planning board was invalid. And there have been other cases that have addressed this scenario as well. So again, what the cases, I think, taken together establish is that if you have a problem, if an applicant has a problem with a particular condition in a subdivision approval, then the appeal process and the 20-day appeal period under Section 81BB is your remedy. But once that period passes, so for example, if the bond is set up such that it covers plowing, the 20-day appeal period under 81BB from the original decision is the applicant's ability to seek redress of that. Once the 20-day appeal period expires, then those appeal rights expire as well. And again, I think this was really a weighing by the legislature of the advantages and disadvantages of, like any statute of limitations, of recognizing that rights will be cut off at a certain point in time if they're not exercised within that period of time.
And I'm still stuck on something that Justice Grant brought up earlier, and it is in 81BB that doesn't characterize what one could get judicial review for. It says any decision. It doesn't say only decisions resulting in change. That's the judicial review provision, not 81W, which I understand have no issue with the appropriateness of Jackson Wood's request under 81W. And it seems to me that the decision denying a request for an amendment is nonetheless a decision of the planning board.
It is a decision of the planning board, but what 81BB I think is talking about is the original decisions of the planning board.
It says any decision.
Fair enough, Your Honor. And the courts have interpreted that section of 81BB and the analogous section of Chapter 40A, which in all respects is substantively identical, to prohibit the kind of appeal, the kind of application for an amendment and then appeal that Jackson Woods has taken precisely in this case.
Are those zoning cases?
They are zoning cases, and,
right.
and I would submit that there are two analogous subdivision cases as well. The Sergi case, and then I think it's the Chucholo case, if I'm remembering that correctly, was a subdivision case as well. We do cite it in our brief. I apologize if I'm referring to the incorrect case.
All right, so I see that your time is up. I'm just going to check with the panel to see if they have any additional follow-up questions for you. I see they do not. I want to thank you both very much for your argument. Don't now 2021-0352. I'm going to begin with a few preliminaries just to remind you of what it means to have an argument in the appeals court remotely again. A little bit of deja vu. First of all, if we have any technical difficulties, please be patient. They're usually resolved very quickly and nobody will lose any time in terms of their argument. The same rules that apply for in-court arguments, for oral arguments, apply on the remote platform. You each have 15 minutes to present your argument, and there is no rebuttal. The last thing I'm going to do is introduce the panel to you. So my name is Ariane Buno, and I'm joined today by Justice William Mead and Justice Marguerite Grant. All right, all preliminaries now aside, and we're going to ask for Attorney Heerdorn to begin your argument.
Thank you. May it please the court. My name is Scott Heidorn and I represent the plaintiff appellants in this matter. I appreciate that you're likely familiar with the facts as alleged in the complaint, so I will only briefly touch on them. Joan Moran was suffering from headaches in 2011, and she was referred to the defendants at the Headache Center, which are the defendants who have been dismissed from this case. They ordered an MRI that showed that she suffered from multiple sclerosis, but they never told her about this and instead diagnosed migraine headaches. She continued to treat with them, but her headaches did not get any better. And on June 11th, 2012, they told her to follow up in 4 months, which would be October 11th of 2012. She did not return then, and the defendants didn't get back to her, but they did continue to prescribe her the same migraine medication. And we allege that they were negligent for continuing to simply prescribe migraine medication when she was not having any improvement. And we now know why, because she was suffering from MS, not migraines. And of course, migraine medication would not help headaches caused by multiple sclerosis. And the last time they prescribed migraine medication was July of 2013. And we allege, with the support of an expert, that each time they prescribed medication after October 11th, 2012, they were negligent. And the theory is that it's negligent to simply prescribe medication without any improvement, without the patient coming back to the office as ordered. And we allege that had they instructed her to come back to the office, they would have realized that the medication was not helping and either ordered another MRI.
Mr. Hydorn, why isn't that continuing treatment? I mean, you've called it continuing treatment.
So it is continuing treatment. And the defendants, when they moved to dismiss, argued that we're relying on the continuing treatment doctrine, which does allow plaintiffs to survive claims that are outside of the statute of limitations, but not outside of the statute of repose. But importantly, that is a straw man argument. We never once claimed that the continuing treatment doctrine applied in this case. We never mentioned.
There's a certain tyranny of labels in jurisprudence, and I think we might have one here. That you admit that it's continuing treatment, and you claim that this creates an exception or brings you outside the statute of repose, and then say that we're not calling it continuing treatment under the doctrine. I mean, that doesn't make sense to me. The legislature made a choice that these actions can't be brought more than 7 years after the causing event, which was the failure to let her know she probably had MS back in 2011, right? That is the triggering event.
Your Honor, I would agree that that occurred prior to 7 years is not at play here. What we're saying here is that there is subsequent conduct within the 7 years that are here.
So how do you distinguish Harvey Rosenthal?
So once again, that case, I believe, is decided under the continuing treatment doctrine. And the continuing treatment doctrine is simply not at play here. We agree, for purposes of this case, that the continuing treatment doctrine does not toll the statute of repose. Does not do that. We're not asking the court to do that. What we are asking the court to do is allow us to proceed with our claims for negligence that happened within that 7-year period. So after October of 2012, when they prescribed migraine medication for this woman, after she was experiencing headaches, continuing headaches that were not improving. We're not asking this court to allow us to proceed with negligence in missing that MRI in 2011.
Was the triggering event in 2011?
Well, there was negligence in 2011 that harm, and there was also negligence.
Can you just answer my question, Mr. Hayden? Please answer my question. Was the triggering event in 2011?
I would agree that it was an event in 2011. With respect to the term trigger, I don't believe that is relevant or pertinent phrase. I don't think that is what is at play here. Under Ruden, the proper analysis here is under Rudenauer, which is a similar, which has a triggering event, if you will, prior to the 7-year period, negligent conduct within the 7-year period. And what the SJC says in Rudenauer is, yes, we need to bar conduct prior to the 7 years, but important because that initial acts of negligence, if you will, if that's the triggering event, just because you have initial.
If I can ask you a question, a follow-up question on that. Let's assuming hypothetically that we were to agree that the prescribing medication I think it was through July of 2013, right? Let's just say the prescribing that was and not seeing the patient was negligent. Well, what was the harm there? There is no allegation that at that point in time, in July 2013, there would have been another MRI or anything like that. What is the alleged harm that occurs as a result of the prescribing the migraine medication in July of up to July of 2013.
What we say is that been instructed to come back into the office where they real medication was not helping and either ordered another MRI to find out what was causing the headache or simply review their own file and realize that they had the answer in it in 2013. And we do have expert support for that, Your Honor, which is important because these other cases cited by the court and by the defendants, they don't have that expert support, and including Rudenauer and the Toas case. But here we have an expert who says this should have been done as harm in 2013, and that diagnosed her condition in 2013 and began treating it then, her condition would not be as bad as it is now. That's the harm.
In Rudenauer, Mr. Hayden, the SJC said that the legislature chose to extinguish malpractice actions 7 years after the negligent acts, even when a doctor's treatment of or responsibility for a condition continued beyond the alleged allegations. Isn't that exactly what's happening here?
It is there no further conduct after that, Your Honor, because Rudenauer specifically says that it does not extinguish subsequent negligence. So what you need to decide here is, were there subsequent acts of negligence within that 7-year period? Because there was negligence before that. And that's what defendants want to say. We were only negligent in 2011, and they'll argue that at trial. But we say no, also negligent in 2013. And Rudenauer says, just because there was negligence before that does not mean that subsequent negligent acts are extinguished. That's exactly what Rudenauer says.
But they limit the when the circumstances have a continuing treatment, it's not extinguished. Did we lose? Yeah.
Yeah, it looks like we've lost you, Attorney Hydorn. Can you hear us?
He was breaking up on my connection.
All right, just wait for a moment, but there we go. Perfect.
Okay.
Started it right.
So
I'm
not
time.
exactly.
Go ahead.
Thank you. I'm not exactly sure where when I cut out, but I was going through the analysis that the SJC says should be used to decide these kinds of cases. And what the SJC says that even if you have triggering events or initial negligence that are outside the statute of repose, if you have subsequent negligent acts, those acts not extinguished just because there's a triggering event before that. What the court says you should do is first, you bar all of those claims more than 7 years before the filing of the complaint. You look at those subsequent acts within the 7-year period. That is not continuing treatment. That's a straw man argument. That's not what we're claiming. We're looking at those subsequent acts of negligence within the 7-year period. Was the prescribing of Medicaid or headaches were not getting any better? The court did in Rudenauer. That's what the court does in Lee and the Toas cases that we've cited, but that's not what the court did in this case. And in this case, what it based its decision on a case Carr versus Pearl, with 17 Rule 128 decision of this court. And the question is, why not? Why Carr versus Pearl follow Rudenauer? And I would say it's because there's a key distinction which makes Carr different from Rudenauer and different from our case. And the reason is,
you're talking about Superior Court decisions, right?
Well, I'm trying to distinguish the Carr versus Pearl appeals court decision from the Rudenauer, which is,
you know, all of those decisions were all decided many years before Parr versus Rosenthal, which is what the judge relied on. And you don't even mention it in your opening brief or your reply brief.
That's correct, Your Honor, because it's not continuing treatment doctrine case. And we're not saying that that is. What we're saying is, what that case did was, that case allowed statute of limitations cases beyond the 3-year period to proceed based on the continuing treatment. The continuing treatment doctrine applies Okay. Thank you very much. So we have cases, in medical malpractice cases, there are two statutes that prevent you from bringing claims if they're beyond a certain amount of years. Claims after 3 years, between 7 years. That's what we have here. You're in between those periods. And here we have what's the plaintiff from the statute of limitations here is the discovery rule. She never found out until she had MS, until right before we filed this complaint. I mean, a matter of days before we filed the complaint in this case. So the discovery rule saves her from the statute of limitations. We do not need the continuing treatment doctrine to save this case from the statute of limitations. And that's what that case is about, the continuing treatment doctrine. This case is not about the continuing treatment doctrine in any way. We're not asking for it. We didn't mention it. It's just not material to this case. What is Rudenauer. That's the case that does apply. And that case, as done by the judges in the Lee and the Toas cases, those are the cases that apply it the correct way. And this court did not.
Can I ask you this? What actually is the holding in Rudenauer? Because what you're talking about seems to be dicta to me, because the claims that I'll call them the claims that the SJC said were outside had a complete failure of proof.
Correct.
So to say that it's that they're outside the statute of repose and actionable, it wasn't the holding of Rudenauer. In fact, Rudenauer emphasized what I read perhaps when you were breaking up at the end, that the legislature made a choice, and perhaps it's a harsh one, certainly in these circumstances, that the claims will be extinguished that occur more than 7 years after the negligent acts or omissions, even when there's continuing treatment, which is what you have here. There's continuing treatment. If Miss Moran never discovered if there was no treatment whatsoever, and she 10 years later she found out for the first time that she had MS, the statute of repose would block that claim as well, would it not?
So what Rudenauer holds is that claims more than 7 years are extinguished, but it says claims that are within that 7-year period are not extinguished because of that. And it's very clear language from the court, even though the court then goes on to decide against the plaintiff. And the reason it does is it says there's no expert support for that. But we do have expert support for that here. So what Rudenauer says is that if you've got subsequent negligent acts and they do state a claim, then you can proceed based on those claims. But you have to do that analysis, and the court did not do that here.
Okay.
So it says my time has expired. Is that all my time, or do I have more?
Yes, we have given you back all the time that was lost during the interruptions. So your time is up. Thank you very much for your argument and your patience. And anything else that you addressed in your brief that we didn't talk about today, of course, it will be preserved. So I'm going to turn now to Attorney Kelly for his argument.
Good morning, members of the panel. May it please the court. Again, Peter Kelly for the defendants, appellees Carolyn Benson, Herbert Markley, MD, and the New England Regional Headache Center. The plaintiff is asking the court to overturn Rudenauer. But one point to make with respect to the plaintiff's argument at this time, with respect to the prescription or allegation of a prescription written in July 2013. There is no claim in the plaintiff's complaint as to that event in 2013. And this was Rule 12 motion to dismiss. Paragraph 40 of the plaintiff's complaint refers to the continuing duty that the plaintiff alleges existed with respect to the care in question. That falls squarely into Rudenauer, Carr v. Pearl that was decided by this court in 2017, recognizing that the statute of repose does not recognize continuous treatment as tolling the 7-year period. So I submit to the court that it is clear based on the plaintiff's complaint the case law that applies to this matter, that the appeal should be dismissed. And just
I'm sorry, Attorney Kelly. Mr. Hydorn says these are subsequent negligent acts that fall that bring him outside, or his claim outside or inside the statute of repose. And Rudenauer talks about such things, but how do you read Rudenauer?
Well, I understand the language in Rudenauer and other cases referring to if there are separate occasions of negligence or alleged negligence that fall within the 7-year period, there may be a basis for a claim, but that's not the circumstance in this case, and the pleading as raised in the complaint by plaintiff. Again, that's why I point to the complaint in the Rule 12 motion. The complaint is silent as to an allegation linking the prescription as being a separate allegation warranting liability on the behalf of the defendants. Again, that paragraph begins in reference on paragraph 40 to the continuing duty. The definitive, definitely established event was the MRI in 2011. All allegations contained in plaintiff's complaint derive from that event in 2011. That is more than 7 years. Statute of repose ought to bar plaintiff's action against these defendants.
Can't the complaint be read as to stating that there is actually an independent event that occurs within the statute of repose, which is the prescribing of medicine, refilling a prescription, if you will, without actually consulting and without actually bringing the patient into the medical offices and performing an examination. Now, whether or not that resulted in harm, which is a question that I asked previously, is a different question. But isn't that an independent claim, an independent act of alleged negligence?
Not in reading the complaint. There's a reference in the chronology to an alleged prescription in 2013. There's no other basis in the record submitted by the plaintiff, even documenting a prescription in 2017, but understanding there's a reference in the complaint. Nevertheless, I would submit that that is insufficient to raise as a cause of action anything related to that prescription.
Would you say, Mr. Kelly, even if they are subsequent or could be characterized as subsequent acts of negligence, it still is extinguished by the statute of repose because the original act is more than 7 years prior?
Yes, that's the event in 2011, the MRI.
I presume if there was expert testimony to say that in the course of the duty and care of a patient, each time that patient comes back to your office, records should be reviewed, or this should happen, or X should happen, or Y should happen. Would you then that might put us in a different situation? Is that correct? In other words, if there was some allegation here in the complaint or something, well, we're only at a motion to dismiss, so that would not have been necessarily much more that would have been required to be added at that point. But would your position be different if that was the case at this stage?
No, Your Honor, because again, I think those are facts most similar to Rudenauer and Carr v. Pearl. Allegations that CTs were performed, results of the CT imaging ought to have been concerning to the physician and warranted some action. That's the same that the plaintiff is alleging here in the complaint. And in both instances, Rudenauer and Carr, the court rejected those allegations because they were trying to establish a continuing treatment doctrine as a basis for liability.
Okay. I apologize. I just have a telephone ringing in the house, which I'm trying to mute out. But what can I do? You're just gonna. I can't also respond and mute out the phone call at the same time. All right. I'm going to see if the panel has additional questions. I don't know,
Just
Attorney Kelly, if you.
one housekeeper. Who was left in this suit, or is it just UMass Memorial? Or Medic?
No, Your Honor. The primary care physician defendant, Dr. Sauls, is left in this case. Would you like to know more about the procedure? I'm not sure how much.
No. I just wanted to know: is the hospital still a defendant?
They are not, Your Honor. It's Dr. Sauls.
Okay.
I could explain why if you're interested.
No, that's okay. He's not a party to this appeal.
Correct.
And just determining that there was no personal jurisdiction over
Precisely. Precisely, Your Honor. And I think that's the central issue, is a very fact-intensive analysis. And I think in our brief, we cited to a handful of cases that would demonstrate to the court that the exercise of personal jurisdiction over Mr. Tan in this case would have been entirely reasonable, foreseeable, and in compliance with Section 3 of the Massachusetts long-arm statute. We would submit that the facts alleged in the complaint that describe Mr. Tan's contacts with Ms. Lacey, as well as the terms of the contract, the key terms of the contract that were cited in the complaint, combined with Ms. Lacey's affidavit that was presented to the court on the motion to dismiss, we would submit that those two documents, the complaint, the key provisions of the contract, and the affidavit, provided the lower court with sufficient facts to justify the exercise of personal jurisdiction. And the key case here is, in our opinion, the COSART case, which we cited in our brief. There's a few additional cases that we also cited that I believe are of particular relevance. The Tatro v. Manor Care case, the Haddad v. Taylor case. The reason why I reference these particular cases is they all addressed what's the fundamental issue here. What degree of contacts is required to justify the exercise of personal jurisdiction in the modern era of email and video and phone call communications?
Let me interrupt you for just a second, because I see your point there. And in fact, I think the judge of the Superior Court did as well when in determining that Jublia, the corporation, there's no cross appeal here. So that's now the law of the case. Jublia is still in the case at this point. Determined that there was sufficient contact to exercise personal jurisdiction over the corporation. But all the cases that you cite and that they talk about that, none of them are addressing what I see as the different issue here is, which is how much is Tan individually responsible, or as the judge pointed out in his decision, that he's simply working as an agent for Jublia. So how do you get individual personal jurisdiction over him when in the allegations are that he was the front person, he spoke with your client, negotiated the contract, was the one to basically fire her, etc. And there is also, of course, the allegation that he is a major shareholder or one of three people that run this international corporation. But still in all, isn't he still just the face of the corporation?
So I would respond to that with 3 points. First, in the COSART case, Horniker was the officer of the defendant company who was also sued by the plaintiff in that case. And I will submit and acknowledge that Horniker, as the officer or corporate agent in that case, he did have a lot more communications with the plaintiff. They had a relationship that spanned many years. And so there were simply more emails. I think the court said there were hundreds of emails and calls between the two of them. Now, I think the Cosart case really is the key case here, because if the court looks at the facts, the connections that Horniker had and the communications that Horniker had with Cosart in that case, it's very analogous to what Tan did here. I think the key difference and what makes the case here even more plausible for the exercise of personal jurisdiction is that you had a consummated contract between Jublia and Lacey, and Mr. Tan was the face, the primary participant in soliciting the employment in Massachusetts, negotiating the contract with her, conducting 2 video interviews with her. He was apparently the only person from the emails that we put in the appendix that she communicated with by email, numerous text messages, and he also was the one who notified her of her termination. Now,
is there any
number 2,
information, excuse me, sorry, is there any information in the record that Tan was had been, fired by Jublia, or had gone out on his own, or was acting without authorization by Jublia?
No, in fact, there's evidence to suggest the exact opposite. There's his own affidavit, which was filed in support of his motion to dismiss, acknowledges that he was still the officer and founding owner of Jublia. So from the time of her contract negotiation all the way through the motion to dismiss, it appears he remained the officer. Number 2, there are numerous case precedent in Massachusetts that support subjecting corporate officers to personal jurisdiction under the long-arm statute when they are, quote, the primary participants in the corporate action. There's a line of cases cited again in the Cosart case that include LaValle v. Parrot Ice Drink Productions of America. I won't list them all off, but there's 4 or 5 cases. I'm happy to provide the court with those sites, via letter after the hearing. But each of these cases demonstrated a situation where a Massachusetts court found that where a corporate officer was the primary participant in the corporate action, that officer was then subject to personal jurisdiction in Massachusetts. And what I think makes this case even more, where I think personal jurisdiction over Mr. Tan is even more likely here, is because we have a statute. We have a statute, chapter 149, section 148, that specifically puts someone like Tan, or in Tan's position as an officer, on notice that if you hire an employee in our state, you will be personally liable for violations of our wage laws, and you will be deemed the employer. And I think that's really a key point in this case, because, and one of the things one of the points I wanted to make today is ignorance of the law is not a defense. And if you look at Mr. Tan's conduct and the communications he had in the context of section 148, he should have known that by soliciting employees in this state, specifically targeting by hashtagging his employment postings with Massachusetts, by doing that and directing that solicitation into this state, he was looking for a Massachusetts resident to employ. And he should have known that that kind of conduct was going to subject him to liability in this state. And the fact that he didn't know that should not allow him to escape personal jurisdiction.
Doesn't Justice Wilkins address that the 148 liability and says that it would be limitless if mere liability is going to establish personal jurisdiction?
I disagree with his assessment of that, because in this case, we're talking about, first of all, a wage statute. So we're talking about someone who directed the company. He was the primary participant in directing the company to engage employees in this state.
Yeah, but can I stop you there? I'm not familiar with any case that has a hierarchy of causes of action that affects jurisdiction.
I'm not suggesting that there's a hierarchy. What I'm trying to suggest is that the fact that the statute exists and it makes it foreseeable that Tan, by his conduct, could be dragged into the state to answer for the company's violations of the wage law. That's really what the point I'm trying to make. And so
then who couldn't be dragged in, as you put it, under these circumstances? If they violated the wage law, who would be out of reach of the long arm statute?
Anyone who's not the president, treasurer, officer, or other manager directing the corporate policy of the company. That would be number one. Number two, though, I think that the Commonwealth of Massachusetts has an interest. And this is something I think the court really needs to address. This is the unanswered question. The court has an interest in allowing employees in this state to address or to seek judicial redress for wage violations that they suffer.
You have a corporate defendant.
I agree, but the legislature in Massachusetts specifically defined the officers of the corporation as being personally liable to disincentivize them from violating Massachusetts wage laws.
You're conflating liability with jurisdiction.
Well, your question was who would be liable, and I'm just trying to answer that question and why I think that this person or this class of people should be liable for wage violations that their companies commit at their direction.
I have a question
look at it from
for you about 149, 148. It starts out, every person having employees shall pay wages, blah, blah, blah. Does that word person include Julia?
Absolutely. It absolutely does.
So doesn't this, how is it that you're saying that 149, 148 needs to include Tan if it already includes Julia?
Well, for a couple of reasons. First, if you scroll down, and there's not really it's page 3 of section 148. And unfortunately, like many of the paragraphs, it starts off with no person shall buy a special contract. The statute specifically reads, and I'll just read it out, quote, the president and treasurer of a corporation and any officers or agents having the management of such corporation shall be deemed to be the employers of the employees of the corporation within the meaning of this section. And so by virtue of that statement, I think the legislature clearly intended to wrap officers like Tan into personal liability for the corporation's wage violations. And there's also another case. So when Justice Gantz was a Superior Court judge in 2004, in Bison versus P-Tech Incorporated, he wrote, quote, in drafting the Wage Act, it appears that the legislature intended to impose personal liability on the president and treasurer of a corporation and on other agents who may not hold these formal titles, but whose actual responsibilities are functionally equivalent to those performed by a corporate president or treasurer. And he went on to write, that is, quote, the legislature did not wish to allow the persons who performed the duties of the president and treasurer to be able to escape their obligations to timely pay wages under the Wage Act merely by giving themselves different titles or avoiding any formal title. And I would suggest the legislature also did not intend to allow officers to escape liability merely by employing people in this state remotely. And in a post-COVID world, this court's decision on this issue has even greater effect and impact because more and more companies are employing people from the state remotely. And if all the officers do is have a few email communications or onboard them as employees and that's it, and they're allowed to escape liability under this statute, then this statute loses its teeth entirely.
Well, not against the corporation, just against the officers and additional people that you mentioned. The Superior Court decision that you just brought up, I don't see that listed in your table of authorities or provided, nor have you provided a copy of that. Do we have that?
It's not, and I will provide that as well as those primary participant cases.
I just need the number of it.
Oh, sorry. It's number 02-2117. And then the site is 18 Mass Law Reporter 417. And it's an 04 case.
Yeah. Okay.
I would just add also that one of the reasons it's important to have this ability, this component of personal liability over the officers, is that it's so common for these companies to simply go bankrupt. I know I've run out of time. If there are any other questions, I'll rest on my brief.
We are now live and on.
Okay, we're going to start again and see if we have a better connection.
Okay.
I'm going to say from the outset that on my end, I do hear an echo, but it's not so disturbing that we can't go forward. Justice Grant and Justice Mead, can you hear things and see things okay?
Yes.
All right. Attorney O'Connor?
I can hear everything, Your Honor.
All right. Mr. Aldalbi, just hold on one moment. I'm going to call the case, number 2021-0400. Mr. Aldalbi versus the Atlantic International Bank. Mr. Aldalbi, would you like to begin your argument or would you like to rest on your brief?
Okay, good morning. Yes, I would like to rest on my case and I remain at disposal for any questions you might have.
Thank you. I'm going to ask Justice Grant or Mead if they have any questions for you.
I have a question now. Are you arguing now that the judge did anything wrong about his ruling that there was no personal jurisdiction over AIB and the Belizean officials?
Are you asking? No, I'm just arguing that I am entitled to go to Maryland, where the acts actually took place by misrepresenting, by omission in a stipulated order to a federal judge, Judge Mesite, which later ruled making depositors liable for the acts of the bank, for which depositors had no act or part or had authorized them.
I have a question for you about the docket in this case. I can see from the docket that you had filed a motion asking for the judge to correct the judgment to order that it was entered without prejudice. And that was, the judge denied that. And then subsequent to that denial, you filed something that's on the docket that I think is in motion to withdraw your that motion that
yes, because at that time I had already exercised my right to appeal, and I was running out of time to appeal. I was concerned about the legal times, something my mother always stressed on me since I was very little. And so I filed appeal. I thought that the judge did not want to deal with this matter. In fact, I think he was feeble, at the risk of enraging you. He was feeble in the face of a federal employee who's now a defendant in Maryland. He missed a motion or disregarded a motion for a discovery and a stay pending jurisdictional discovery, both jurisdictional discovery that were relevant. And in his reply, he forgot to see the evidence in my reply that showed that there was an interactive feature that had started back in 2015, I believe, or early 2016, and went right through the liquidation until I made you aware in the court, and then subsequently they shut down the website. And this was put before the judge. He did not deal with it. I'm happy to go to Maryland. In Argentina, we say if you get burned with milk, you see a cow and run. And so I would like you to let me run to Maryland, where I can seek justice for something that the true issue here for me is the lie I lived since 1982 when I came back to the United States, and my high school teachers taught me that this was not a communist country, and that these things did not happen in communist country. It is something that has depleted my compass, my moral compass, my views on democracy. They are obliterated by this situation. And I ask you, for that reason and that reason alone, and not because the defendant agreed that Maryland would be an alternative, but that would be the only alternative, to let me go to Maryland so that I can exercise and recuperate, or at least test once more whether this is a communist country where the government seizes private property without cause. What act did I commit? How can you say that there is no merits in this claim? It's something profound for me. It's I'm sorry I take it so personally. I go on, and at the risk of offending you, because I know Americans are very proud people and don't like to be told by foreigners outside views, but I can't hold my tongue. And I have a failback, a safety, a fallback. If you decide to say that that I don't have the right to go to Maryland, then I will go to the judge in Maryland and say, well, they had no authority because they relinquished jurisdiction to further speak. And I think, from what I've read, and I'm not an expert, you certainly are wiser than me, federal courts say once you do not have jurisdiction, you should be quiet. You muddy the waters, you're not efficient, and you lack comity, more importantly, from my perspective. That is, the judge in Maryland was happy to take the case. The defendants did not argue that this motion had been denied with prejudice. If this goes back with a ruling by you saying, well, this was with prejudice, then the judge might find an exit to the situation he's in, which is having ordered $13 million of private property to be seized without cause. Never I could have expected that in Argentina. In Bolivia, I was ready for that possibility to happen. In Italy, ready to come, with cause or without cause. But it's the first time for me in the beacon of democracy after growing up here since elementary school, then university, high school, worked in the finance sector in New York, always believing these principles in the Bill of Rights. I even took my son to the mall, to the archives, to look at those bills of rights. Today, I think I
think we understand where you're coming from. We can understand your passion as well. But what's before us here is this discrete issue, which you've described well, and you've also set forth in your brief. So I think we have a good handle on what it is that you're looking for and why it is that you're seeking it. So I just want to check to see if my fellow panelists have any specific questions for you at this point. No. Okay. All right. I think, as I said, I think we understand what you have to say. If you want, you still have a little bit of time. If you want to sum up, fine. If not, I'm interested.
No, I think like a colleague of yours, the president, one of the hearings, I think I'm going to stay and not run the basis.
Okay. All right. Thank you very much, sir. So we'll turn now to Attorney O'Connor.
Thank you, Your Honor. Very narrow issue presented here which is what's the preclusive effect of the judgment entered by the court below. It's the position of the Belizean defendants that all that was decided below was that there's no personal jurisdiction over them, and that the decision is with prejudice as to that issue. And Mr. Aldabe is not free after this appeal to bring another case against the Belizean defendants over this subject matter, or really anything else, in the Commonwealth of Massachusetts. He's already exercised his right to bring essentially the same claims or similar claims against these same defendants in United States District Court for the District of Maryland. He's added the Federal Trade Commission to that case. That case is proceeding apace. And there's a motion to dismiss by the Belizean defendants pending in that case. And no argument has been made that what the judge did in the Superior Court precludes that case from going forward. Much the same argument is presented in Maryland as was presented here, which is that there's no personal jurisdiction over these defendants in Maryland. So I think that the result of this case should be that the dismissal is with prejudice as to the issue decided, no personal jurisdiction over these plaintiffs, over these defendants, I'm sorry. And there's no other controversy between the parties. We offered to stipulate to that, and that offer was not accepted. So if you have any questions, that's really all I have to say. The case law relied upon by Mr. Aldabe deals with subject matter jurisdiction. I'm not sure that's the same thing. That goes more to the power of the court to act. I think the court certainly had the power to render a decision on the merits as to the personal jurisdiction question, and it did so. And that decision should be left permanent. It's not even appealed from here.
All right, well, I think we understand your argument as well, but I'm gonna double check with the panels to be sure that there's nothing we've left unanswered. I see that they're both in agreement. So there is no rebuttal in the appeals court. Thank you for participating in the remote platform today. We've had a couple of technical difficulties this morning. They were all resolved quickly. So if we have any during this last argument, I'm sure they'll be resolved as expeditiously as the others have been. And I can assure you, you won't lose any time if that's the case. The panel hearing your cases today consists of me. My name is Ariane Buno. I'm joined by Justice William Meade and Justice Marguerite Grant. So with that said, Attorney Bass, you represent the appellant, so the floor is yours.
Thank you, Your Honor. Good morning, members of the panel. I'm Attorney Andrew Bass. I represent the appellant Donald Cameron. Today we're here on two questions. Number one, whether the appellant is entitled to a trial on his claim for relief under Chapter 93A in relation to the Lemon Law statute, which is Chapter 90, Section 7.5. Specifically, under Chapter 90, Section 7.5, the statute states that any consumer dissatisfied with any finding of a state certified new car arbitration shall have the right to file a claim pursuant to Chapter 93A. Mr. Cameron, the appellant, did conduct an arbitration in 2018 in relation to an alleged defective vehicle. The vehicle was a leased 2017 Jeep Wrangler. In that arbitration, Mr. Cameron did not prevail, and so he filed a complaint in the Superior Court pursuant to the sentence I just read off from the Lemon Law statute under Chapter 93A, among other claims. And in the lower court, the judge found that essentially the judge's findings, which are included in my brief, stated that Mr. Cameron could not survive a summary judgment from the appellees because of the fact that he lost the arbitration. Mr. Cameron today is arguing that pursuant to the sentence in the statute allowing him to file a separate claim under 93A, the judge should have basically heard the Superior Court case from first impression and not just relied on the arbitrator's decision
the arbitrator's decision, Mr. Beth, is prima facie evidence of propriety, right?
Well, I think the statute's a little unclear about what exactly then if the arbitrator's decision is prima facie evidence of whether or not the defects, whether or not the vehicle is a lemon, it's a little unclear then why exactly the statute states that the consumer dissatisfied with any finding of the arbitrator has a right to a separate claim under 93A.
But there has to be an independent basis for it.
And in Mr. Cameron's complaint, Mr. Cameron details the fact that the manufacturer failed to effectively evaluate the vehicle, failed to respond to his demand letters, and failed to make repairs and failed to make good faith repair attempts on the vehicle. And that was under the 93A section of the complaint. So
just to clear things up, we're talking about the ignition problem and the stall. We're not talking about the squeak, right?
We're talking about all of the issues of the vehicle.
Well, they resolved the squeak, is that right?
That's correct, Your Honor.
And they couldn't replicate the ignition issue you claimed, right?
That's correct, Your Honor.
And thereby they were not, having been unable to replicate it, they were not given an opportunity to fix it.
Well, Your Honor, actually to that point, on June 6th of 2018, which is post the arbitration, Mr. Cameron alleges in the complaint that the vehicle shut off and he crashed into a guardrail. And in fact, Mr. Cameron's motion for summary judgment was accompanied by an affidavit attesting to those facts. And the manufacturer didn't present any evidence to rebut that. And also the manufacturer didn't present any evidence at all in their motion for summary judgment aside from an attorney's affidavit.
Is Mr. Cameron's own self-serving affidavit sufficient for summary judgment purposes?
Well, Your Honor, we had pictures of the vehicle crashed attached to the complaint in this motion for summary judgment. And once again, I'll emphasize that the manufacturer had no evidence in support of their motion for summary judgment, aside from whatever pleadings had been filed and an attorney's affidavit, which is, you could argue be self-serving as well. To go further to the second question of this appeal is whether or not Mr. Cameron was required to have expert testimony at this juncture in the case, or expert testimony at all. And I pointed out in my brief that the case of Thomas R. Glidione, the Ford Motor Company, decided by this court July 31st of 2019, states that when the defects are so apparent, essentially in the vehicle, it's not necessary for a consumer to have to hire an expert witness and spend substantial amounts of money to demonstrate something that's so clearly apparent. Now,
okay, let's assume that it doesn't have to be expert testimony, but it has to be something. What did you submit that rebutted the prima facie case?
Well, Your Honor, I think the central thing that we had at that point was the vehicle shutting off and Mr. Cameron colliding with the guardrail. I had photographs.
Go back to the same affidavit?
Yes, Your Honor.
So, okay, all right.
The manufacturer also did take possession of the vehicle during the course of the Superior Court litigation and did inspect the vehicle with their own expert. However, they never disclosed the findings of that report, and also that report, if there was one, or whatever findings there were from their inspection, was not included as part of their motion for summary judgment to once again disprove Mr. Cameron's allegations of subsequent defects after the arbitration.
Where does the requirement they submit that report come from?
Well, there's no requirement, Your Honor. However, Mr. Cameron did make allegations in his complaint that defects did occur after the arbitration, including the vehicle shutting off while driving, which was not something that was originally raised in the arbitration. And the manufacturer never submitted anything to disprove that. I mean, they did argue that they never had the chance to look at the vehicle or repair it, although they did take possession of the vehicle and had their expert inspect it.
Did you raise the claim, the 93A claim, in the trial court?
I did, Your Honor.
As an independent basis?
I did, Your Honor.
But you didn't oppose FCA's cross motion for summary judgment?
I rested on my motion for summary judgment.
So that's a yes.
Yes, Your Honor, I did not oppose it.
Attorney Bass, you still have some time. If there's anything else you would like to bring to our attention, you don't have to use the time. I think you've covered all of the issues that you wanted to highlight for us this morning.
Thank you, Your Honor. I have one just final point, and I believe that the statute, the way that it's written, suggests that a consumer who's dissatisfied with the finding of an arbitrator under the new car lemon law statute is entitled to essentially file an appeal of that decision with the Superior Court and have the case reheard. And in this case, the judge took the arbitrator's decision and relied on that solely, I believe, in rendering his finding in this case. And the statute's quite vague. It says any consumer dissatisfied with any finding of state certified new car arbitration shall have the right to file a claim pursuant to Chapter 93. It doesn't even say dissatisfied with the findings of the arbitrator. It just says dissatisfied with the findings of the new car arbitration. So that could mean any element of the arbitration, not just the defects of the vehicle, but the efforts of the manufacturer to make remedy, repair, investigate. So that's all for now, Your Honors. And panel, thank you. I'll rest on my brief.
Okay, well, thank you very much. Before you sign off, I'm going to check with Justice Mead and Grant to be sure there's no additional questions. I see none. Thank you very much for your argument. Attorney Scans, the floor is now yours.
Great, thank you. And morning again to the panel. I represent FCA US LLC. It's the defendant in the matter. An important issue that I think needs to be raised in the context of this appeal is the burden that Mr. Cameron held in this matter. Procedurally, the summary judgment motion that was initially filed by Mr. Cameron was opposed by my client, and there was a cross motion, which was simply never opposed. And under Rule 56, there's a requirement that a party oppose the underlying motion with proof in admissible form, whether it's affidavits or portions of the record, to refute those arguments raised on summary judgment. It's not simply in the context of a summary judgment motion to rely on the complaint or allegations, or in this case, positions taken in the first filed summary judgment motion by the plaintiff. Instead, the plaintiff had a burden of submitting evidence to counteract, to refute, or to oppose the underlying summary judgment motion by FCA. And that's important in the context of this appeal, given the arguments raised by Mr. Cameron. First and foremost, the issue regarding the independent claim under 93A is nowhere in their brief. And in the context of FCA's cross motion for summary judgment, the argument raised in those papers and at the hearing before the trial court judge was that the Lemon Law claim was a derivative, the 93A claim rather, was a derivative claim of the Lemon Law claim. They're intertwined such that if the Lemon Law claim fails, so too does the 93A claim. There was no argument raised in opposition to that by Cameron in the trial court in their papers or at oral argument. And our position is that that is waived and is not properly before this court on appeal. Even if they had raised the argument, the trial judge's reasoning was sound. There was no independent basis at all in the record to support a 93A claim that stood alone beyond the Lemon Law claim. And in fact, I believe
what about, I'm sorry, Dan, what about the two demand letters?
The two demand letters are in reference to the underlying claim for violation of the Lemon Law, and the complaint itself was, I mean, in other words, Your Honors, the claims are that the vehicle was defective and not timely repaired, and there existed a nonconformity. And the underlying claim is that FCA did not comply with an obligation under the Lemon Law, which the consumer requested a refund. So the factual analysis under both claims are intertwined. They're derivative in the sense that there's no independent basis, for example, a sales issue that would give rise to an independent 93A claim, or some other allegations of unfair or deceptive conduct independent from the underlying claim that the vehicle was defective and it wasn't timely repaired. In other words, they're intertwined in the context of the factual allegations, and certainly the claims asserted by Mr. Cameron in the complaint and before the trial court were in fact a derivative claim. In fact, Attorney Bass at oral argument even framed the issue to the trial court in that way. This is primarily a Lemon Law claim. What they're arguing before the court today is that under the section of the Lemon Law itself, the consumer has a right to bring a 93A claim, which is true. It's a 93A claim based upon and derivative from the Lemon Law claim. And so our position is that the underlying 93A claim was properly dismissed by the trial court, both procedurally because they failed to raise that issue in opposition to our motion, and on the basis that there was nothing to support an independent 93A claim, which brings us to the Lemon Law claim, which is first and foremost the highlight of the claims brought by Mr. Cameron. And the issue framed by Cameron on appeal, that the trial court's decision was based solely on the lack of an expert, is somewhat missing the point. In fact, as I come to again, the consumer in this case had the underlying burden to prove a claim at the arbitration level. He did not prevail. The statute under the Lemon Law states that the findings of fact of the arbitrator, in other words, that the statute was not violated, are prima facie evidence before the trial court. So Mr. Cameron had a second burden in front of the trial court judge to refute that prima facie evidence, that there was no violation of the statute. The third burden he held was to oppose our summary judgment motion, which established by undisputed material facts that there was no issue regarding the essential elements of the claim. One being whether there was the same nonconformity that was subject to an unreasonable number of repair attempts, whether that nonconformity existed after a final repair opportunity was provided to the manufacturer, and whether or not there was a substantial impairment to the value, use, or safety of the vehicle. The facts before the trial court and the record showed that there were three issues raised by Mr. Cameron. The first was a squeak issue, which undisputedly, and as was stated on the record here today, was repaired timely. There's no violation of the statute where an item is repaired timely prior to the claim even being filed and prior to any notice of a final repair opportunity. The second issue raised by Mr. Cameron regarding the ignition switch was not duplicated by any technicians. There's no, in the context of this case, and if you follow the reasoning in the Jackson v. Honda matter, which we cited in our papers and decided by this court in 2009, while the consumer does not have a extremely strict burden of demonstrating the precise technical nature of a defect, they do have the burden in the context of a Lemon Law claim to show that a defect can be duplicated and can be experienced by a technician. In the Jackson case, interestingly, the consumer did have an expert. And even with that expert testimony, because it wasn't sufficient to overcome, like here in the context of the ignition switch issue, the fact that the technicians at the authorized repair facilities couldn't duplicate the issue, the court still found summary judgment in favor of the manufacturer appropriate. I also add, with respect to the ignition switch issue, it was only subject to, at most, 2 repair attempts. And unlike significant issues which could have been duplicated in other cases, for example, the Gliatone case, which is cited extensively in Mr. Cameron's brief, that was a case where there were verified issues of stalling, inability to start, lack of power over the course of 6 visits with repeat repair attempts. And the court in that case held that in certain contexts, expert proof may not be required because an issue is simple enough for the average juror to understand that all of those verified concerns can give rise to a finding of fact that there was a defect. I also note in that case that the Gliatone v. Ford matter that there was no opposition at all by Ford that the vehicle had been subject to a reasonable number of repair attempts. In other words, there were 6 verified issues. The only concern was, or the only issue before that court was, do you need an expert, yes or no? So the holding in that matter did not state that a consumer never has to have any burden to have expert proof to prove a lemon law claim, and certainly didn't say that the consumer has no burden at all to demonstrate the underlying elements of the claim. In this case, Your Honors, the plaintiff was bound to demonstrate proof in admissible form of a nonconformity that was subject to an unreasonable number of repair attempts, continued to exist, and was substantially impaired the value, use, or safety of the vehicle. They didn't do so. In a normal context, the motion for summary judgment was properly granted. In this context, in this case in particular, where you had an arbitrator's decision, which was prima facie evidence the statute wasn't violated, Cameron had an enhanced burden, which the lack of expert evidence simply was the nail in the coffin, so to speak, that he had no material evidence to refute summary judgment in favor of FCA. Let me just note simply that the stalling concern, which is the subject of what we've labeled as a self-serving affidavit by Cameron, wasn't subject to any repair attempts, because again, to the extent that it was subject to one visit that happened after the arbitration decision itself was rendered, it too was never duplicated by any technicians. And although Mr. Cameron argues that he was involved in an accident, clearly in the context of an accident, if you read the cases even cited by the Gliatone v. Ford matter, in which the court summarized those instances where expert testimony was required, in the context of some accident, which is being alleged for the first time after the arbitration itself, to which the vehicle was subject to no repair attempts, Cameron has at least the burden through expert proof to connect those dots between those allegations, putting aside the fact that he never afforded FCA the underlying requisite repair opportunities which were necessary to even support a lemon law claim. I also note that the second necessary element under the lemon law, that the nonconformity itself substantially impair the value, use, or safety of the vehicle, is an element which stands alone. In other words, certain issues are minor enough that doesn't matter how many times the vehicle is subject to repair, there's still a necessary burden on the consumer to show a substantial impairment to value, use, or safety. In this case, again, in the context of the summary judgment motion that was filed by FCA, Cameron never opposed. Cameron never disputed any of the material facts which supported that motion, and Cameron had the burden in the trial court to submit evidence in admissible form to refute those undisputed material facts under Rule 56. He failed to do so, and so there's no evidence that he could point to in the record that shows he was able to overcome those findings by the trial court, especially in the context of the prima facie evidence on that element, which was the arbitrator's finding of fact in that regard. So to summarize, I know I have a little bit of time left, and I can certainly answer any additional questions. The arguments raised by Cameron are procedurally ineffective, given the fact that he failed to raise those arguments in the trial court properly, failed to meet his burden, which was established both by FCA's underlying motion and the arbitrator's decision against him. And we ask that the trial court's decision be undisturbed.
Thank you for your argument. I'm going to check with the panel to see if they have any additional questions with respect to any issue in the case. I see not. Well, thank you both very much. The arguments are very helpful. We'll take the case under advisement and we'll get an answer to you as soon as possible.